It all started out where Skylar Richardson, our client, pretty high school graduate, had gone back to her OB/GYN office, and they asked her where was her baby? How did her baby turn out? Because she had been there back in April, which was about 4 months before this second visit, where she discovered that she was pregnant. And she told the OB that she had a stillborn and buried it in the backyard. The OBs did not know what to do. They finally called the cops a day later. The cops immediately taped off the house where Skylar lived, taped off the entire backyard, etc. And all of a sudden, it was a major news story regionally. The cops had requested that Skylar go to a local police department where they had a 8x12 interrogation room. They put her in there. Her father told her, just be truthful, don't worry. Just tell him the truth. He was told that she was a witness, not what this case was all about. So she's interviewed by 2 cops for about 4 hours, tells them exactly what happened, very detailed. As a result of that, they take her back to the backyard where she shows them the gravesite. After that, they leave with the instructions to her parents that they don't know what she's going to be charged with, but it'll probably be something like reckless homicide, nothing real serious. Between that first interview and then there was a second, the cops were told by the coroner's office, the forensic pathologist, that the remains had been burned. This is after they dug up the bones. This led to the second interview, during which they got Skylar to admit signs of life, that she did burn the baby, that she put a match to the baby's leg and it caught fire, that she then buried it. After that interview, she was taken directly from there to jail. We got a call from a law firm here in Cincinnati, a large law firm that knew us by reputation. And Charlie took the call. And we were first thinking it was, according to the lawyer who got us involved, it was a reckless operation, which is a minor traffic violation. Charlie, you want to take it from there?
Sure. And so we met with Skylar and her mom and dad together pretty quickly and asked her what could be the worst thing that you said to these police officers in these 2 interrogations. And that's when we learned that, although it's not true, she told the police that she tried to cremate her child after delivering her child. And my dad at that point said, yeah, that might be a key to this case. And it ended up being a huge key to this case because it helped us explain, and actually, despite our burden of proof not being anything, proving that this false confession where you have a young teenager who is appearingly being questioned in a very soft, gentle manner, saying that she might have killed her child, that she might have heard her child gurgle, seen her child move, and then burning a child because of the impossibility in the science that we'll talk about later in this presentation. The things that they got her to admit to defied logic and common sense and science, and that helped us show that this was a false confession. So that was a huge part of the case.
I can imagine, and the whole thing about not having a burden of proof, I don't know what world you live in, but if you're dealing with drunk driving, anything that has to do with sexual assault or children, you generally have, child abuse, something like that, you generally have the burden of proof to prove your client innocent.
And you get to go last.
Pardon me?
And you don't get to go first.
Right. Or last typically. But so
true in Ohio.
That's the challenge of being a criminal defense lawyer, right? That's why, that's why.
So
So
That's why
then-
they don't make movies about prosecutors, all right?
So there was a preliminary hearing scheduled, which is just a probable cause hearing in a lower court. The prosecutor asked us to continue it, which we did because he wanted to make sure he understood the case, et cetera, which we now know was bullshit. The next thing we know, he announced, well, take that back. We went to see him thinking that we could figure out, really, was this just an abusive corpse? You know, she had a stillborn, this and that. And he said, no, I don't think so. And he kept telling us to ask our client. We kept asking him, what do you have? What's so terrible here? Ask your client, ask your client. Well, shortly thereafter, he indicts her and he holds a half-hour press conference, which just lit a match to a tinderbox.
Before we jump into the press conference, though, let's show everyone a picture of Skylar and her family in court, one of the court appearances, just so they have an idea what we're looking at in terms of, you know, we've got Skylar is the young blonde woman. That's her mom right next to her, and her dad, Scott, behind her. Upper middle class family in a small community here in Southwest Ohio, extremely conservative venue. Jurors in our community, we go by who votes, 65+% Trump country, to give everyone an idea. And John can jump in later on this venue and how he helped us. But, you know, because we've got a good looking family, middle-class family in the suburbs, it garnered even more media attention than it might have, I think, otherwise. And the prosecutor, as my dad was mentioning, jumps in. If Dan, if you want us to, we can show some of the pieces of evidence that they used, or I think it might be better later in the presentation. We could probably just jump into the press conference if you'd like.
That sounds like a good plan. And on top of that, it follows the outline we saw his time putting together. So I think it's a great idea. These guys are, Charlie Jr. is a rule follower, not Charlie Sr., just so people know. Did you have the same problem with him, Campbell, when you were working with him? Go on, sorry.
All right, this is the prosecutor, the head prosecutor of our county.
And what we've done here, we spliced up, he had about a 30-minute press conference immediately after he unveiled this indictment, which was like throwing gasoline on a fire in our community and nationally and internationally, actually. And so Elias clipped this so that we get the highlights in just a minute or two.
The general allegations against her are that sometime during the night of May 6th to May 7th, 2017, that she did give birth to a newborn infant, and that she caused the death of that infant. She subsequently burned the infant and buried the infant in the backyard of her own residence. Skylar and her family, and particularly her mother, were pretty obsessed with external appearances and how things appeared to the outside world. And you have a situation where, you know, she's a cute high school recent high school graduate. She was a cheerleader. I think a lot of this, from my perspective in viewing this evidence, came down to a situation that if members of the community were to find out that the Richardson girl was pregnant and perhaps gave birth, and even if after giving birth gave that child up for adoption, that was something that simply was not going to be accepted in that household, at least by Skylar and her mother. And so I think that from my perspective, was one of the primary motivating factors in terms of what happened. And there is evidence to a reasonable degree of medical certainty that the bones that were recovered from the residence in Carlisle were charred. They had burns on them. And so we know those things to a reasonable degree of medical certainty. We're trying to, you know, obviously get into a situation because, you know, these were charred remains.
So you're describing a spoiled, self-entitled teenager who was more worried about vanity than keeping the life of a baby alive. That sounds really horrible.
Those are your words.
So was this the prosecutor who tried the case?
He did not. He's our elected official. Two other prosecutors who actually do try cases were the ones who tried the case.
All right. Go ahead.
I know people will be shocked to know that some of the things that he said turned out to be absolutely not true. But he did have some, for this prosecutor, he had a confession, which was false. He had text messages immediately after Skylar had the stillbirth and buried the fetus in the backyard. She texted her mother and her boyfriend talking about how happy she was that her belly was back. And he had an admission in the confession that Skylar had said that she had some Google searches looking into abortions, and her words were, and I think I might have Googled how to get rid of a baby. So the prosecutor did have some pieces of evidence that we had to overcome. And I'll let my dad jump into kind of how we started thinking about the case. And I think it'll be a good segue into John Campbell, who really helped us distill things here.
At this point, shortly after that, within minutes after that press conference.
Charlie, before you get on to this, let me ask you a question though, because it's hard to tell because of your youthful appearance, but how long have you been a criminal defense lawyer for?
42 years.
And how many times in the past have you had to go to trial with a confession that was false as a major piece of the evidence?
Probably none that I knew of at the time. None that I can remember, quite frankly.
Okay. Because there's really nothing, as a criminal defense lawyer, there's really nothing tougher than the confession, no matter how they got it.
Correct.
Everybody says, I would never confess to something I didn't do. I mean, every human believes that. But I was just curious because, well,
you always have clients that say, no, I never said that. And you read it in the police report that they did say that. And then you have the evidence which clearly supports what they said in their confession. So you do have that. But I never had one where I really believed it was a false confession. And we believed Skylar from the get-go, as they say.
He's had cases where he believes that the accused didn't say certain things that the cops claimed, but now that we have video and audio, that's really coming into practice more recently.
Yeah.
Right, which makes life a lot easier in demonstrating the potential false confession when it was just the cops' notes before.
It really does, Dan. But to what you mentioned earlier, the one, people's gut is, I'd never confess to something I didn't do. And two, people think that false confessions are a product of being almost abused in a confession room, being yelled at, books slammed on the table, threatened. And in this case, a technique known as the Reed technique was used, which is a very common interrogation method that can elicit false confessions. And it is a soft but very sophisticated approach and you'll see in these interrogations, one of the female detectives is holding Skylar's hands in a very loving, caring manner. If I didn't tell you as a police officer, you might have thought it was her mother. And They're using this coercive method known as the Reed technique. So that made it even more difficult because Skylar was never threatened by the police. She was never spoken to with a raised voice. She wasn't there for more than 4 hours at any one time. And she was there voluntarily and signed her Miranda warnings.
Mm-hmm.
Now, as part of the Miranda warnings in Ohio, because they don't do this, we're in Michigan, where I practice like criminal law, does the officer tell the suspect or the person that he will lie, trick, and deceive them in order to extract a confession out of it? So that way it'll make his investigation go a little faster because then he doesn't have to gather evidence. Is that part of the Miranda warnings in Ohio?
No.
I wish we'd gotten a little addendum to that. I might ask the courts to see if they'll put that on there.
They should. I mean, that way people know what they're up against when they're dumb enough to trust the police. I'm just curious. Okay, go on.
I mean, most people, and you would know this too, don't realize that the cops can lie to you. Yeah, true story.
And lo and behold, that's exactly what happened in this case.
Wow. All right. I didn't mean to interrupt Charlie Sr. Go ahead. I just needed to ask those couple questions because, this is our first time meeting really. So this is like, who is this legendary trial lawyer that, I was going to ask you how your son got so handsome if you're actually his father, but I thought that's a story for another day.
Thankfully, got the looks from my mother.
That's right.
No kidding. Go ahead.
Well, shortly after that press conference, this case was known from that point forward as the burned baby murder case. Headlines, the whole works. And anytime there was any type of hearing or whatever, there'd be 10 cameras, etc. So we knew we had our work cut out for us. So the first thing we did is think of the experts that we needed. We contacted, I tried to get a local guy here, a psychiatrist who had, I'd been told, had some kind of interest in false confessions. That gentleman never called me back. So I then found a gentleman by the name of Alan Hirsch.
Where's he got?
What's that?
Where's he from?
He's from Massachusetts.
Okay.
He's been, he's an attorney by training. He's a professor at, what's that school where they play football? No, they were in
Holy Cross.
Holy Cross. I believe he's a professor at Holy Cross. He's done tons of research and he's written a number of articles, etc., regarding false confessions. So when I contacted him, he became very interested, asked us a few questions. By that time, we already had the videotapes of our client's interrogation. We retained him to give us his opinion. We sent him the tapes. He gave us an opinion that he thought that she was subjected to the Reed method and gave a false confession if it were to be believed, for example, that she did not burn the baby. Throughout when I was dealing with him, he was a great expert for me because he made my life easy. He actually was familiar with the law in Ohio. We also did our own research, which is, there aren't very many cases on it, but he gave me the outline to use when I was going to question him on direct, which was nice. He also told us that it would be essential to have a psychologist run a battery of tests on Skylar to determine whether she has a personality disorder that predisposed her to submit to people in authority. And one of the reasons for that is that normally false confessions arise from a situation where you have an 8-hour or a 12-hour interrogation. Here we had 2 4-hour interrogations. So based on that, we hired a gentleman by the name of Stu Bassman. He has a national reputation as a sexual victim psychologist expert type thing. But he also worked for not only our common pleas court there in Warren County, but for other courts too, as helping offenders, etc. So he gladly took on the case. He found that she had a personality such that she was predisposed to submit to authority, which was a key to linking in the fact that she gave a false confession. Also, while we're doing all that, I got a hold of a good friend who does med mal defense and asked her if she knew any OBs locally, because I wanted a local OB because I thought that that might give that OB more credibility. And she came up with a gentleman by the name of Dr. John White. And John, I contacted him. He'd only testified maybe 4 times in a court of law. His office was here in Cincinnati. And John was interested from the very start, despite people telling him that he shouldn't get involved in this particular case because of what they heard through the media. John also not only looked at the interrogation tapes, but also got all her medical records, looked at her school records, which were kind of important with regard to, these are physical exams done by the school I guess it was school doctor or whoever.
Yeah.
And little tidbits came out there that was very helpful. Weight, for example, because she had an eating disorder and her weight would fluctuate between 100 to 150 pounds. The fact that she didn't have a period for a year, that kind of stuff was very, very helpful in him coming to his opinion and diagnosis that this child was stillborn, and suffered from what is called interuterine growth restriction, IUGR. And what helped him or convinced him of our client's innocence was the fact that during her first interview, and I don't know if we're going to see clips from the first interview, but the cops asked her about the cord. When the baby came out, did you cut the cord? And what did you cut with? She said, I didn't cut the cord. She didn't know the significance of that. She also described the baby as being white, eyes closed, no heartbeat, all that other stuff. And it described perfectly, at least for Dr. John White, that the baby was stillborn. And statistically, based on her health issues and the fact that she had just discovered that she was pregnant about 11 days prior to giving birth, he came to his opinion that this baby was growth restricted, which was very helpful. He was also very helpful for me. I spent hours with him trying to learn the medicine, and he helped me with cross-examining another well-known doctor here, a Dr. Brady, who is known to defend doctors in med-mal civil trials. So we then also we knew the state had a forensic anthropologist who was local, by the way, well-known, Beth Murray, and she's the one that had opined that the bones had been charred. We got a hold of a gentleman, his last name is Sims. He was down in Mississippi. He had an international reputation as a anthropologist, a forensic anthropologist. And he happened to work at the Mississippi Coroner's Office, which is statewide. And he worked with a Dr. Levon, who was the forensic pathologist, who did over 700 autopsies a year. For example, in our doctor, our forensic pathologist, may have done 100 in 1 year, which is still a lot. So, and this gentleman, Dr. Levon, probably testified, I think he told me 300 or 400 times a year, all across the state of Mississippi. So that was our lineup. And we can go into other stuff later.
Jump in it, John.
Oh, we also, once we got our facts together, et cetera, and what we knew of the state's case, we decided that we needed to focus group this. And Charlie got a hold of one of his very good friends, a gentleman by the name of Craig Shaprizi, who does plaintiff's work out of St. Louis. And Craig knew John Campbell, or knew of him. Charlie contacted him, and I'll let Charlie tell the rest of the story.
So we got in touch with John. I'm going to let John tell the story because he's hugely helpful. That was the first time I'd ever met John through a good college friend of mine who's an excellent plaintiff's lawyer out of St. Louis with his sisters and dad. And he knows John, who's from St. Louis. First time we've ever used him. I can tell you that we're going to use him more and more, and we've used him multiple times in both civil cases and criminal cases, but I'll let John jump in on this case.
All right. Before we jump in on this case, John, we need to get some background on you and how it is that you got to this position in your life, from being a lawyer and a law professor now to doing this big data Moneyball jury information.
Yeah, it's funny you say Moneyball, because sometimes we call this jury ball. And we got here, I got here kind of in the order you just described. I started off as a plaintiff's trial lawyer in St. Louis, working for John Simon. He's an inner circle member, great lawyer. And I learned how to try cases. And then, God, almost 10 years ago now, I took a job as a professor at the University of Denver Law School. And my plan was I'm going to keep working cases, but work a few less and teach some and kind of have a mix. While I was there, I started meeting people, not law professors, but people, sociologists, social scientists, economists, who were doing big data studies. And so, they had moved away from the model we all learned in Psychology 101 of getting 80 grad students and talking to them about, hey, what do you think about this? Or doing an experiment on their students or volunteers off the street. And they were all starting to get people, when they wanted to study something, they were using online workers, because even back then, way ahead of COVID and ahead of the gig economy, really, there were people that were starting to look for extra work online. And that work would be, it started with Amazon saying to people, hey, we'll pay you to sort pictures, give feedback on the layout of a screen, read text and tell us what you think, catch errors, whatever. So Amazon built something they called Turkers, Amazon Turkers, and created something they called HITs, which are human intelligence tasks. And so when they couldn't write code for something, they'd hire people to do on-demand work. Eventually, they turned that platform loose to everybody who wanted to recruit workers for anything. The first people to really jump on it were researchers. And they figured out, hey, we can get 400 or 500 people from all walks of life, from any state or from all over the country, to look at things and tell us what they see. So of course, if you're an economist and you want to do an economics game, you could have 500 people play the game and manipulate things and get data. And they started checking, and sure enough, if they did online studies, they got results very similar to if they did some of the famous historical studies with people in a lab. And they said, well, this is better. We can get more people faster, and we get them cheaper because we only need them for the time we use them, and they can sit in their living room if they want, or at their office or whatever. So I started playing around with that just on my own cases, and my wife, who's also a trial lawyer, her cases. And then John Simon, who I mentioned earlier, called and said, I got an opioid overprescription case. And it was a great case on liability, a very hard case to value on damages. And I said, hey, instead of doing a traditional focus group, let me put it in front of 400 or 500 people. That's going to let us do some cool stuff, because now we can show 1/3 of the jurors one damage request, 1/3 another damage request, 1/3 another damage request, and we can do A/B testing. We can see which one turns out best. And since we got so many people, if we see a difference and that's all we change, we'll know it did something. We can also then say, hey, on average, jurors give this much money, but are there characteristics of jurors that predict good ones and bad ones, so that you can load the jury with the good ones and exclude the bad ones? So we started doing the stuff that I always tell people, if I went to Google and told them what I do, they'd say, hey, that's neat. Thanks. We've been doing it 20 years, because they use big data. They work hard on statistics. They use statistical analysis to figure out what matters and what doesn't and make decisions. But we started doing it on our own cases. And then we got invited to start talking to other attorneys about it. And it turned into studying juries completely by accident that we got into the business. Since then, though, we've gotten very busy at Empirical Jury, and we've studied cases in, 40 states. And I think last week we hit about $600 million in verdicts we've been involved in on the civil side. And we've gotten the fortune to work with folks like Charlie and Charlie on some really interesting criminal matters.
And I know last Friday you added 30 million to your total because of Christian Morris and Sean Claggett, who are going to break their case down on this coming Friday. So it's, hot off the presses, but that's for another conversation, because we're going to finish talking about this. We'll talk about that a little bit later. So that's how you got started. So what percentage of your case is criminal versus civil?
We're probably at 15 or 20% criminal, and the other 80% civil. And you can imagine why that is, right? Is because the criminal case has to be pretty substantial to justify the expense. But I think we're doing more and more of that, because frankly, in the criminal context, in some ways, it is perhaps more essential to figure out, because we learn a lot about which jurors to seat and which jurors to avoid. In all cases, sometimes you get no selection at all. In criminal cases, generally, you will get a little more selection, just worried about due process a little more than they are in civil cases.